Hello, I'm Elliot Hack, Community Relations Associate here at University House, Wallingford. Before we start today's presentation, Ike Elmo would like to share just a little bit about our beautiful community and our speakers today.
Hello, everyone.
Hello, everyone. I'd like to welcome you also here to University House Wallingford. We're so glad that you're here. We have a series of presentations like this throughout the year, and that is the mantra of our community is lifelong learning and bringing valid information to you. Thank you, Elliot. In affiliation with the University of Washington Retirement Association, University House Wallingford residents benefit from the partnerships developed with the University of Washington School of Nursing, Social Work, and Pharmacy to deliver innovative programs designed with healthy living and lifelong learning in mind. If you are considering making a move to a retirement community, you are welcome to arrange a visit and explore everything we have to offer. We'd love to give you a tour of our community and talk about our independent living and future health options and how our waitlist works. And now the main event. Janet L. Smith, founder of Northwest Elder Law Group, is an attorney providing services in elder law, estate planning, estate administration, guardianship, TEDRA disputes, and elder mediation. She has been licensed in the state of Washington since 1983. Peggy Sanders received her law degree from Northeastern University in Boston. She began her law career as a litigation attorney in Honolulu. Before joining Northwest Elder Law Group, Peggy had an elder law practice in Edmonds, Washington. Peggy is a past president of the Washington Academy of Elder Law Attorneys and was their member of the year in 2017. Peggy's law practice includes elder law, estate planning, long-term care planning, probate, guardianships, and vulnerable adult protection. Thank you so much for joining us today. Janet and Peggy, welcome to University House.
Thank you.
Thank you, Ike and Elliot, for having us. We're really pleased to be here. I wish that we were there in person. As those of you who have seen this presentation before know, I love to speak in public and see the audience as I talk to them, but this is what we've got right now. And so we'll try and make this Zoom webinar as close to an in-person presentation as we can. What we're going to do today, we have a short amount of time, so we can't cover all of the details that go into planning for how your affairs are going to be handled during your lifetime and after your death. But what we hope to do is give you a brief overview today of the important legal documents that everybody over the age of 18 should have, ways that you can make sure that your wishes are carried out during your lifetime, and ways to minimize conflict with your family and others during your lifetime and after death. So that's our goal today, is to just give a brief overview. Now, Ike mentioned that both Peggy and I are elder law attorneys. And what that means is that elder law attorneys have a holistic practice that focuses on the needs of elders and persons with long-term care issues or disabilities and their family system. So that often involves estate planning, guardianship, protection from abuse, and probate. And both Peggy and I have that kind of a practice. So I'm going to start with the title to our talk today. It's called Getting Your Ducks in a Row. And I often tell the little story of what does getting your ducks in a row mean? I mean, we all know it means getting your affairs in order, but where did that phrase come from? And as I've researched it, there are many theories. And the theory that I like is not that it's a little row of ducklings following along behind mom, but that in early colonial America, they had a game that was similar to bowling, and that game was called duck pins. And so one theory is that getting your ducks in a row meant setting up your duck pins for this early American bowling game. So now you have a little bit of trivia that you can tell your friends. And the next, it's kind of hard. Usually I ask this as a show of hands, and we can try that for all of you. You can raise your hand as I ask the question. And the question is, if you only had one estate planning document, what's the most important document to have? How many people, raise your hand if you think that's a will. Okay, and raise your hand if you think that that's a durable power of attorney. Okay, so Peggy and I have an opinion about this, and that is that the absolute most important document for everybody over the age of 18 to have is a durable power of attorney. And this is a document during your lifetime. And so now I'm going to toss it to Peggy, and she's going to talk to you about durable powers of attorney.
Thanks, Janet. I appreciate that introduction because I often would have the same question for people I meet with. Which one is most important? And so I want to talk a little bit about what a power of attorney is and what it's not, because a lot of times we run into situations where there are things that folks want to do that may be not covered in a power of attorney. So I'll start with what it is. And what it is basically is a legal document where you sign this document and say that you authorized someone that you name to step in and manage things for you if you're not able to. And the reason why we think that it's so important is that it comes into play most often if you have an accident or something happens medically. Somebody can step in and take care of things while you're not able to do that for yourself. So the reference to durable, you heard Janet say durable power of attorney, and that reference is that a durable power of attorney continues to be in force and effect even if you become incapacitated. There's a long Old English history of what a power of attorney is. And the basic bottom line for that historically is that when there was a power of attorney, the attorney in fact, who is the person you name in a power of attorney, steps into your shoes and can do whatever you can do. The problem is if you can't do anything, then it kind of limits the power of a power of attorney unless there's language in the document that says that the effectiveness of the power of attorney will continue even if you become incapacitated or otherwise not able to handle your affairs. And there's two kinds, if you will, of power of attorney. One involves finances and one involves healthcare. And the one that involves finances, basically, I'd like to say that you're giving your car keys, your checkbook, and the deed to your house to somebody that you really trust. And it's a little overstatement in that because even if the power of attorney is in effect, you still have the authority to say what you want. So it's a little overstatement, but you're basically trusting someone, and I apologize. You're basically trusting someone. I'm going to put it on do not disturb so you don't get any phone calls. You're basically entrusting somebody to take over for everything that you need to do, pay your bills, make sure that the mortgage is paid and the property tax is paid, and do not disturb. Boy, that's a handy thing. So given all that, one of the things I like to discuss is who you choose as the person or the person to serve as your attorney of fact under a power of attorney. And I'm afraid I'm often apt to refer to movie movie resource or sources when I'm talking about things. So this one I get from Indiana Jones, and it's the movie where he's trying to find the oh goodness, but anyway, sorry about that. And he ends up in a cave, and there's an old wise man that say you have to choose the right goblet, and the old guy says choose wisely, and that's what I like to emphasize. Choose wisely when you're talking about who you want to name as a power of attorney. We've had situations where people come, people have said, okay, I want my eldest to do it, and then by age. Well, that may work fine, but you want to make sure that your eldest has the same values that you do and is responsible financially. So make sure that when you're looking at who you want to name as attorney in fact, you really can trust that person to step in and do what you would do. The interesting part is that there are restrictions. There's some restrictions on what an attorney in fact can do for you. And that is, the most important one is the principle that the power of attorney needs to do what you would have done or what they think you would have done in the same circumstance, which is why I like to say, make sure that they share your values, that that you can rely on them financially. So the other thing that they can't do, which sometimes people worry about, is that they can't make you live in a nursing home. They can try to provide care for you in the best place and resource and so forth, but they can't force you to move to a nursing home. And then what they are authorized to do is pretty much limited by what is in the written document. So if one of the examples I was thinking of was the ability to give gifts. And the attorney, in fact, can give other people gifts only if they have authority in the document to do so. So, your attorney, in fact, can't just give away all your money. And the final protection is that you can revoke a power of attorney at any time and for any reason. So you have you retain the authority for your own decisions, but this person can step in when you can't. And I think that's really important. And the other type of power of attorney is one for healthcare decisions. And that one is really important because there are very few people that can get medical information about you unless they have a power of attorney or some sort of authorization. And that's what ends up happening sometimes is, your kid comes in, but because you don't have a power of attorney, your kid can't get information on your care or make decisions for you if you're unconscious. And so that's what makes it really important to have not only the documents in place, but the people named in your document that you can trust with your life and your money. And Janet, did you want to add anything or any thoughts?
I think another factor about powers of attorney that we always talk about with clients is whether they're going to be effective immediately or effective with a doctor's letter. So could you talk about that?
Great, yes. So the power of attorney can go into effect the moment you sign it or only upon your incapacity. And that's where you get, so who decides if you're incapacitated? Usually the document will say in itself will say that I'm to be considered incapacitated when my primary care physician or two physicians certify that I'm not able to manage my finances and my healthcare decisions. We usually recommend, if at all possible, to have a power of attorney effective immediately. One of the things that we run into sometimes is when someone becomes incapacitated, we have to find a doctor who will certify that they're incapacitated. It kind of adds to the length of time before the power of attorney is effective, and it can be a little difficult to get doctors to sign those certifications, and sometimes you need some help right away. I think the other thing to emphasize, however, is that you have, bottom line with a power of attorney, you're the one that has the final say. So even if the power of attorney is in place immediately, that doesn't mean that your attorney, in fact, can go off and sell your house or something. You still have legal authority to do what you want to do. And this really is something that you can veto certain decisions if necessary. The state of Washington is very, very concerned with maintaining personal autonomy and authority. And so even though you've signed an immediate effectiveness, you still retain authority over your own stuff.
The way we're going to do questions today is we're going to ask for questions about the topic that we're talking about. So if anyone has a question about durable power of attorney for finances or durable power of attorney for healthcare, go ahead and put that into the chat right now. And while we're waiting, I'm going to ask Peggy, what happens if I've never done a power of attorney, but I'm in an accident and I'm at Harborview and I'm unconscious? What happens then?
Great, great question. There are a few people who are designated by statute to be able to work with the doctors. But without a power of attorney, it's not a foregone conclusion that you're going to get anybody who can work with you. Let me put it that way. And what happens is doctors and hospitals will do anything and everything to treat your condition. And that's probably okay if you're in an accident, but if you have a long time illness, you may not want to have that full amount of treatment. And I think we'll talk about that a little later in the presentation. But say you have a long time illness, you've been sick and you have dementia. The only alternative for you if you don't have a power of attorney is a guardianship. And a guardianship is a court process where someone comes in and petitions to be your guardian, and the court looks everything over and makes a decision, an order, whether or not you need a guardianship and who should be your guardian. And that is a public process. People can go to the court and look up your name and pull out. I mean, you can't get it online, I don't think, but if someone were curious, they could go to the court and see the documents. It's expensive. It takes a long time, and it's not a great alternative to signing a power of attorney.
So we have some questions coming in. Who draws up a power of attorney? Does that have to be a lawyer?
Well, in self-interest, yes, but no. There are some good sources. You can use a power of attorney. I hesitate for the online things because it just, if your family and your situation is just like everybody else's family and situation, it makes perfect sense. I hesitate on that, but there are sources out there. And I think, Janet, if you have the same idea, there's the form from Washington Legal Help is fairly complete. there are some things that we add in light of specific situations, like will your power of attorney have the authority to choose your caregivers and choose the place where you're going to live and so forth. So we add more detail in a lawyer prepared one. But I know that even hospitals have their forms, so it's better than nothing.
Right. I typed into the chat WashingtonLawHelp.org, and the forms are, they have a packet about powers of attorney that is pretty good. And so you can go there, look under the topic of seniors, and you'll find that. A question says it's important to remember also that the DPOA, POA ends when the person is deceased. The appointed executor takes over, right?
Right. Great. Yes. The power of attorney actually ends the moment you pass away. And your affairs are then taken over under the probate process, or if you have other things in place. There are a couple of things that we like to bring to our clients about that. Sometimes in the gap, there are things that need to be signed and things that need to be done, particularly about your funeral arrangements and so forth. So we always add a designated document that will allow you to designate somebody to do those things for you after you pass away and your power of attorney ends. But that's a great question. And the answer is yes.
Okay, and then this is going to be the last question about powers of attorney, so we can move on. But this is a good question. If a doctor or two says you're incapacitated, does that affect your decision-making or vetoing ability over the power of attorney?
That is a fabulous question, and the source of many, many, many times of discussions and talks everywhere, and issues with our clients. The true answer is, what does the document say? Most of the time, the document says you can revoke power of attorney at any time. And that's true whether doctors say you're incapacitated or not. Janet, do you have some experiences that you can share on that regard? Because it's a great question.
Yeah, so the difficulty is when a client, say a client comes to us, we've done their power of attorney, and now they have dementia and they're confused and maybe they're a little paranoid and they want to fire their power of attorney. And we as their attorney don't think that's a great idea. One of the first things I would do is I would counsel them about what's likely going to happen if they do that. And if they are at a point where a doctor would say that they didn't have the capacity to understand that decision, then revoking the power of attorney at that point might be a very bad decision, because it could result in a family member or the state petitioning to appoint a guardian and putting more restrictions on the person. So as their attorney, we would counsel them. But the bottom line is a power of attorney is a voluntary document, and it becomes quite unworkable with financial institutions if the person is saying that they have revoked it or want to revoke it. And so I'd say that the legal answer is a power of attorney can be revoked even by someone who is incapacitated, but that what generally follows after that is a guardianship petition in most cases. So it's a troublesome time.
And I think part of this also is, here's an example. I have a power of I gave a power of attorney to my daughter, and she wants to sell my house, but I want to live in it. And somebody, we find that a lot too, right, Janet? I mean, we find it and the daughter comes in and says, oh my gosh, I have to sell this house because mom's not safe. Even with decisions that aren't full revocations of the power of attorney, I think that would still end up sort of in the same place, that mom could make that decision, but it may turn out that further protective things would follow. Is that, you agree, Janet, on that
Yeah,
one?
and I think that the last thing I'll say about powers of attorney before we move on is that if you are serving as the agent under a power of attorney, as the attorney in fact, you can consult with an attorney, and we would think an elder law attorney would be very appropriate in this circumstance to tell you how to do that job. And so if you're running into problems with the power of attorney, an attorney can guide you about the best way to proceed using that document and to make sure you're doing it right. So I'm going to move on now to our next topic, which is, so powers of attorney are all about how do I make sure my affairs are handled during my lifetime in case I become incapacitated. And so the next topic is, well, okay, after I pass away, and my funeral has been arranged by my designated agent for that, now what happens? And generally at this point, people think about, what does the will say? So one misconception about wills that I find is pretty common is that folks assume that your will, being such a significant document, controls all of your assets, no matter what. And the answer to that is no, that's not true. There are assets that are governed by your will. Those have the term, they're called probate assets. And there are assets that are not controlled by your will because something else has taken place. And those are called non-probate assets. And that would be if you have an asset like a bank account where both you and your spouse are owners of that account, and the owners have rights of survivorship. So in other words, it's a co-owned bank account where when one person dies, the other person owns it. That asset is not covered by your will. The other is where there's a beneficiary designation. If you have a life insurance policy or an IRA or a 401k or a brokerage account, and when you set up that account or at some later point, you filled out a form that designated beneficiaries. And sometimes it can designate a primary beneficiary, which might be your spouse, and contingent beneficiaries, which might be your kids. Those beneficiary designations take precedence over your will. So if you have almost all of your assets in these accounts that name beneficiaries, your will is not going to cover very much. And so sometimes people set up elaborate schemes with percentages and charitable donations in their will, but then there isn't very much money that the will controls. Now, what does the will control? The will always controls real estate. I said always. There's an exception to that, but it's not something that we need to cover in this presentation. But you're generally, your will just direct where your real estate goes. It will control your tangible personal property, which is the fancy legal name for your stuff, your cars, your boats, your jewelry, your artwork, your collection of Hummel figurines, your baseball card collection, all of that stuff. And your will controls any financial account that doesn't have a co-owner with rights of survivorship or a beneficiary designation. So one of the reasons I talk about that at a presentation like this is for many people who have sold their real estate and moved to a retirement community, your estate may not need to go through probate. It's still a good idea to have a will, but it's possible that your beneficiary designations will take care of everything that is needed to pass your assets along to the people or organizations that you have designated. And you can also designate a charitable organization in a beneficiary designation. So that's important to remember if you want to make some charitable gifts from those assets. One of the questions we often get in these seminars, and I'm going to go ahead and answer it before somebody has to type it in, is I've heard a lot about trusts and revocable living trusts. And maybe you read Susie Orman's columns. I saw recently she even writes a column in the Costco newsletter.
Oh no.
So Susie Orman tells everybody that everybody needs to have a trust instead of a will. And I'll let you in on a secret. Susie Orman lives in a faraway place called California. And all states have different probate processes. And some of them, like California and Arizona, probate is kind of a hassle. And there are fees associated and there are rules, and it takes time. And it's such a hassle that the vast majority of people will put their assets into a trust for the primary purpose of avoiding probate. Now, we're lucky that we live in Washington State, because Washington has a pretty straightforward probate process that is not overly expensive or burdensome. And so as a general rule, we look at everybody's circumstances. And I would say that for the vast majority of our clients who do not own any property outside of the state of Washington, we recommend a will as being a simpler and more straightforward way to control the distribution of your assets, even though it might have to go through probate. We look at all the circumstances and say, you know what, you're just not going to get that much benefit from a trust, and there's a certain amount of expense and hassle in setting up a trust and managing it, that we generally recommend a will. Now, also I found in presentations to places like University House is that some of you have moved here from California or Arizona or another state where you had a trust, and you want to know, is it okay that I have this trust? And absolutely. If you've already done the work to create that trust and put your assets into the trust, that's just fine. And there's probably nothing that you have to do. That trust will be effective in the state of Washington. If you want to make changes to that trust, it's a fairly easy process to do an amendment to the trust. Say you need to change the distribution of the assets after your death, or say you need to change who the trustee is going to be after you step down. And you can at that time also change what's called the situs, where the trust lives and is interpreted. You can change that to the state of Washington, so it's interpreted under Washington law. So it's a pretty easy process to amend an existing trust. And so we do that all the time for our clients who have already done that process. But if you're starting out fresh, chances are we're going to recommend a will rather than a trust. And to define what a trust is, the simplest way to think about it is it's a container with rules. Okay, so your trust is a box that you put stuff into, and the box has rules about who can manage those assets, how they're going to be managed, after your death, and things like that. So not a complicated process, but with a will, all of the assets stay titled in your name, and the will directs what happens to them after your death. So I'm going to open up questions about wills or trusts. And Peggy, if you have any questions, you can ask me as well.
I'm just, I do, and I think I sent one, but anyway, I have a concern, and I've always had an opinion about whether or not somebody should put their kids on their bank account. Do you have any thoughts about that?
Yeah, it's a lot of times people will do that for convenience. And the first question I ask a client who's asking me that question goes back to Peggy's advice to choose wisely. You don't want to put anyone on your bank account that you don't absolutely trust to respect what they're doing on that bank account. One of the problems with putting your child on the bank account is that banks have pretty much a default setting that if you don't make it really clear to them whether or not this person on the account is a joint owner with right of survivorship, that's what the bank's going to do. So if you have 3 kids, but your daughter Sally lives here in Seattle, and you go down to the bank and you put Sally on your bank account, and your other kids live in Boston and Maine, places Peggy has lived, and so they're not on your bank account. And say you have $100,000 in those bank accounts, and that's a pretty good chunk of what you own. And you didn't make any special provisions when you put Sally on there. You pass away, and the bank tells Sally, okay, Sally, it's your money now. You can do anything you want with it. And your other kids might not like that. It can cause problems in the family. So sometimes families are very, very close. Sometimes it's your only child and they're going to inherit everything anyway. So that doesn't create any problems. And sometimes Sally is extremely responsible, and there's no issue that Sally understands that after your death, she's going to use that money to pay any final funeral expenses, credit card bills, your medical bills, et cetera, and then split it 3 ways with her siblings. But if that's not explicit and understood, then I think, and I think Peggy might agree with me, that a better way to do it is for Sally to take the power of attorney that names her first and that says it's effective immediately, take that down to the bank and have them make a copy of it and say, now add me to the account as a power of attorney, and be very specific with the bank that they are only adding you as a power of attorney. That doesn't come with any ownership rights. It only comes with management. And so now Sally can pay your bills, get your bank statements, reconcile your checking account. But when you die, Sally doesn't own that money. So it kind of depends on the circumstances of the family, but probably the better course of action is to have someone on the bank account only as a power of attorney and not as a joint owner.
While we're waiting for other questions, there's also some things that come to mind, and folks have come into my office and said, my Sally is just the most responsible person in my life. I'm going to give her everything and trust that she's going to distribute it to her siblings. Also, I think it's not a good idea.
Yeah, that's putting a big burden on the family member who you've given that role to. I actually have that situation going on right now where a woman had 2 daughters and a stepdaughter and didn't make a will, but had kind of verbally said, I want you to share. So without a will, the woman's estate goes to her natural children. The stepdaughter was never adopted, but they then have the burden and the guilt of trying to know if mom really meant share everything equally, give her something if she needs it. It's, one of the great gifts that you can give your family by doing clear estate planning documents is to just put in writing exactly what you want to happen, and in a document that requires that that's what's going to happen. You're not doing your family any favors if you leave those decisions up to them later. It's much better, in terms of specifying what healthcare decisions you want, specifying what you want to happen to your assets, what you want to happen to your stuff. It's just better to actually put your wishes down in writing and take that burden off of them. Okay, it looks like we have some questions. My will is a paper document and I have the only copy. If I change my mind and want all my assets to go to my natural heir, can I just tear up the paper will? Legally, that is true. And this goes back to, we get a lot of our law from Old England. And the law of wills says that one way to revoke a will is to destroy it. The problem in modern times is that there are going to be copies out there. Among other things, your attorney's office is probably going to have a copy from when they made the will. And if you have not made it clear to your family or possibly your attorney that you are intentionally destroying your will in order to revoke it, then there's going to be confusion about whether you destroyed it or whether you lost it, because wills do get lost sometimes. And then there's a process for proving that the copy was what you intended. So yes, you can tear up your will, but it would be a really good idea to tell someone, whether it's your attorney or your family, and somehow put it in writing, I am revoking my will. Probably even better to just do a new will that says I leave everything to Sally. Because you ultimately, lawyers' jobs is to avoid ambiguity and lack of clarity. And so we will go, that's why sometimes our legalese gets a little convoluted, is we are trying to do everything possible to avoid anything from being interpreted more than one way. And so the absence of a will, unfortunately, can be interpreted as John ripped it up to revoke it, or John was really unorganized and he accidentally recycled it. So you want your wishes to be clear. Okay, what if you have two kids, both of whom live in Seattle? Any problem just adding them as owners of various bank accounts? Again, we look at all of these situations on a case-by-case basis, and one law that folks on a bank account sometimes aren't aware of is if all of the money in your bank account is yours, it's your income, your Social Security check goes in there, but your kids are on the account. They are listed as co-owners by the bank, but they are not the legal owners of that money while you're alive. And so if they're on that bank account, you want to not put anybody on your bank account who might think that, hey, I'm listed as an owner on this account, so I can pay my Visa bill out of this account. because that actually is stealing and they could get in trouble for that. So you want to, again, only proceed with kids that you trust. Make sure that they understand that this is for convenience only, that they are not to use any of that money for their own purposes. It's still all your money. And again, look at the pros and cons of, would it be better for them to have access to this money after my death, or are there risks involved with that? So a lot of these situations, there's no one single right answer there. The answer is, it depends. That's usually the answer. Okay. Does the child with power of attorney need to be a Washington resident? Peggy, why don't you take that one since it's powers of attorney?
You got it. You got it. And the quick answer is no. There's a lot of ways that, particularly with finances, that these days you can do finances online. You can do automatic check or automatic payments. And there's a lot that you can do from far away. So no, your power of attorney does not need to be from the state of Washington. Sometimes people like to have their power of attorney for healthcare close by so they can dash over to the hospital if something happens, but even that is not required.
Yep. We have also had situations where an agent under a power of attorney is not in the United States. And while that is not prohibited, it can sometimes create issues with financial institutions that like things to be simple. So if your only living relative is in Vancouver, BC, think about whether that's the best choice to name as your power of attorney, or whether there might be someone that you could name that would be in the United States, which raises a question that usually gets asked in these seminars. And I'm going to ask you, Peggy, what if I have no family, or I have no family that I would trust with this job? Who do I name in my power of attorney?
I was thinking about that very thing, Janet. That was great. There are more and more of us that may not have family members, or they may, my brother's in Thailand. I wouldn't want him to be my power of attorney. It'd be too hard. There are professionals who will serve as attorneys in fact. I usually recommend that if someone is in the space where they need someone who's professional, that they interview them, and spend some time talking to them to make sure that they feel comfortable. But you can hire folks who will step in when the time comes. And some of them are more expensive than others, but there are some really reasonable folks out there who can serve as your power of attorney when you need it. So you're not, all alone, just mostly alone. And the other thing is that, without a power of attorney, you're probably going to end up with a guardianship anyway, and you won't have a choice about which professional is, appointed to step in and take care of things. I'm all about having choice. And if you can choose ahead of time, even if you don't need it for a couple of years or a couple of decades, if I'm all about having the choice of who you have to serve as the person who will come take care of your manage your finances and healthcare decisions. So fear not.
I have a question, Peggy. If I have a very, very special family heirloom, and I have 3 kids that I know are all going to want that special family heirloom. What's the best way to deal with that to avoid them fighting over it?
Oh my goodness. Well, I think the best way to deal with it to avoid fighting between them is to make the decision yourself. And when you do a will, you also have the ability to do a handwritten list of tangible personal property, not money and not real estate, but tangible personal property. And you can write the list, say, I want Sally to have my heirloom necklace, and you date it and sign it and keep it with your will. And I'm going to be facetious here. And someday you get really mad at Sally and say, no, I'm not going to leave it to Sally, I'm going to leave it to Jane. And then you don't have to change your will. You've just changed that list, date it and sign it. So that, in my opinion, that's the best alternative. I think it beats the yellow stickies that people often use. At least it has the authority and the validity of a legal document.
And a cautionary note, because I had this come up in one of my cases. Mom had 2 kids who really hated each other, and she was smart enough. She named a family friend to be the executor. She knew that neither one of them would be happy if the other was the executor. And she made a very, very detailed tangible personal property list of all of her stuff. But like all of us these days, she primarily worked on her computer, and she was in the process of revising her list. And there was a draft on her computer that had not yet been printed out and signed and dated. And one of the kids was trying to say, well, she meant for me to have the purple bookcase. And I had to break it to him and say, you know what? A draft isn't valid if it's on the computer. For a tangible personal property list to be valid, it has to be signed. So if you're working on that list and you work on your computer, print it out whenever you make changes and write the date and write your signature on it. And then you've done your task, and do that every time you make changes, because anything that's in your computer is not going to count. Quick question, when should you review your documents? Is there a rule of thumb? There really isn't. You should review your documents when your circumstances change. So if there's a change in your family, a change in how you feel about your family, who you want to serve in different roles. Maybe you named Sally as your agent when she lived in Seattle, but now she's moved to go be with Peggy's brother in Thailand, and that's no longer convenient. So anytime there's a change, and powers of attorney, the financial institutions get a little nervous when those are over 10 years old. They're perfectly fine. They're perfectly valid if you have a power of attorney and the person who made it is now incapacitated and can't redo it. That's what you've got, and the banks have to accept it. But if you have the choice of freshening that up every 10 years or so, that's not a bad thing to do. Not a bad idea if all of your documents were created in another state to update them. They are all valid here. They are legal documents that are covered by the full faith and credit clause of the Constitution. So a document executed in another state is valid in any of the other 50 states. But there might be some slight changes from state to state that you would want to update them. The other thing I'm going to say about that, and it's on your handout way down at the bottom, is know where you put your original documents. Going back to Old England again, the law is very backwards, and we don't yet have legal electronic wills that's coming, but it's not here yet. Your will and your power of attorney for finances are the two documents where you really, really want to have that original. And there's only going to be one original. Probably best not to put it in your safe deposit box because that can be very hard to get to. There's a Murphy's Law that says if you need to get into your safe deposit box, it's going to be, at a Sunday at 3 a.m. So we advise people to keep them in a safe place in your home. That might be a filing cabinet. It might be a firebox that you buy at Home Depot. It might be a notebook on a shelf. It's okay to 3-hole punch the documents. It might be a little paper folder that you put them in and put them on a shelf. It might be in the drawer where you keep your passport. The important thing is you make a decision. I am putting my originals here, and you make a note of that and you tell somebody else so that they know if you're incapacitated where they can go to find that original. Okay. Let's see. I want to catch all the questions. Sometimes it may be okay for kids to write a check if one trusts them, right? So the question there is, if they're not a signer on the bank account, the bank will not allow them to sign a check. So they do need to be on the bank account in some form, whether as a co-owner or as an agent. And yes, there will be a point where so you want somebody else to be paying your bills, but those checks are to pay your bills or for your benefit, and not writing a check to themselves or to pay their own debts. Okay, just one person for financial power of attorney, but healthcare should be more than 1, 3, so there can be a tiebreaker. Peggy.
Oh boy, and that is a question we get all the time. I have 3 kids. Shouldn't all of them be on the power of attorney? The answer is legally, sure. Practically, maybe not so much. And what I talk to people about is that, we're back to the choose wisely, because what you want is someone who has the decision-making power right away. So they can talk to the other siblings, they can consult, they can do all that, but somebody has got to sign the check or sign the consent form at the hospital. What I usually discuss with my clients is, what if we did it such that, Sally was first, Jane was second, and if Sally can't do it, then Jane would do it. And if Jane couldn't do it, John would do it. So that you have all 3 of them in the document, but you have you have someone who has the final say, basically, to be able to move forward on things without having to get everybody in the same room or what have you. And I have heard from clients that even if we have language in the power of attorney that says all 3 of them are power of attorney for finances, but they each have the authority to act on their own, the banks are not happy with that. And I've had clients who've had to get all 3, for example, to sign on a particular piece of a particular document in order for the bank to accept it. And when you have 3 active kids who have jobs and so forth, sometimes it's hard to get that done in a timely way. So if my client says no, it's important to me that all 3 of them have to be on the document, we can do that. It's just like Janet was saying about having your kids on your bank account. You just want to be. My job is to inform the client about what could happen down the line if that's the path they choose. So that's my answer.
And I would say that for healthcare, medical providers are used to working with entire families and making sure that everybody is comfortable with major decisions. So I'm much more comfortable putting Sally or Jane or Tom as my healthcare agent, any one of them can act independently. The reason for that is a healthcare power of attorney might be called into use for very mundane things. My mom was in a nursing home, and whenever she needed a flu shot, they had to get my approval. Well, you don't need 3 people approving the flu shot. So you definitely want that act independently language, but you tell your family that I want all 3 of you to be on the same page if it's a life and death question, if it's the decision of, am I going to have chemo or not? Am I going to, have hospice care? And generally, medical providers are good at working with families until everyone is comfortable with the decision. I would say if you know in advance that your family is likely to have a serious disagreement over a healthcare decision, it's possible you can put a tiebreaker and say, in the event they can't reach consensus, then Sally shall be the decision maker. But it might solve a lot of conflict to simply not include the person whose values are not the same as yours. If you have a family member who, doesn't have the same end of life values that you do, it's probably avoiding trouble if you don't have them making the decisions for you. And sometimes I've had situations where, people just simply say, my spouse would not be able to make an end of life decision for me. So I'm leaving my spouse off and naming my kids because I know that they're going to be more clear-headed about it. So it's all of these documents. Bottom line, which I think you probably have figured out from this presentation, is that you're in the driver's seat. Our job as attorneys is to tell you, the things you don't know, to tell you what the legal requirements of the document are, and to tell you what might happen if you make this choice or that choice. But ultimately, you're the boss, and you tell us what to put in your documents, and we try to find the most unambiguous and legally appropriate way to phrase that in the documents to carry out your wishes as you tell them to us. Okay. Okay, so Elliot's going to take care of the handout if anybody didn't receive it. This one's your choice. Should I leave my money to my children or my grandchildren or both? Our job is not to advise you where to leave your money. Sometimes people ask us what is typical, and we can talk about that, but that's the hardest part of your homework. So when we are starting a new estate planning session with clients, we give them we have a questionnaire that they fill out that names the people they want to name and gives us a snapshot of your assets and all of that. But the hardest part of that homework sometimes is the decisions. And we have to take those decisions from you. And my biggest word of advice on that is, don't let the perfect be the enemy of the good. That's an old tried and true phrase. And one of the saddest situations we ever encounter is when somebody is having a lot of difficulty deciding how to leave their estate, and they don't get around to it. And they die before they get those documents in place. And then it's almost a guarantee that whatever happens without the will is not one of the choices that they were deciding. And so my advice to everybody is, get your estate planning documents in place. You can always change them as long as you have the capacity to do that. You can always, play around with it and tweak it, but have something in place that is what you want today. And don't leave it to whatever the default setting is, the laws of intestacy or, a guardianship petition. We want you to have your wishes in writing. Elliot, we're at about 11:35. Should we just leave it open for questions now?
Sure, let's give it a few minutes for see if any other questions come
Okay,
in.
any question on any topic that we've touched on?
While we're waiting, Janet, one of the things that has come up a couple of times with clients of mine is they've appointed one person as financial power of attorney and one person, a different person, as healthcare power of attorney. And then now they are incapacitated, and the financial power of attorney doesn't want to pay for the things that the healthcare power of attorney thinks are very important for the well-being of the person who wrote. I understand, and a lot of times what happens is that people have said, well, I'm going to name the financially responsible one as the financial power of attorney, but I don't want my less financially responsible one to feel left out or insulted or anything. So how about I put that person as power of attorney for healthcare? Sadly, in those situations, you're often left, well, I don't know how often it is, but what I see when people come into my office is that the two can't get along. And it turns into a real power struggle, and the person who's suffering is the one who is incapacitated. I'm thinking that if a client is really clear that they want two different people, I'm thinking that one of the things that we can do to carry that out is to make sure that there's language in both that says who gets the final say and who directs the attorney of fact for finances must pay for, the needs as identified by my power of attorney for healthcare. I'm not sure I see anything else to do with that situation other than guardianship, and we know we don't want to go there. Do you have any thoughts about that, Janet?
Yeah, we've also put language in a power of attorney that says something like, it is my intent to stay in my home with in-home care, even if that is a more expensive option than other care options, so that it's very clear that this is what you've chosen and you want your agent to pay for that. But the other idea that pops up when you say that, and a lot of times we've been talking about families who aren't on the same page, whether it's how to provide care, how to manage resources or whatever. And another option is bring in a third party as a mediator or a facilitator. And sometimes that's an elder law attorney. I perform that service. Sometimes it's a geriatric care manager or a social worker. And a lot of times people can be a lot more rational and a lot more civil when there's a third party in the conversation, moderating that, facilitating, directing, asking probing questions. And sometimes issues can be resolved where everyone is on the same page by having a little third party help with that. Okay, my son is in New York. Where do I find somebody who can do the details to help him out when I die? That's a pretty easy question if it's just the process of, opening a probate, distributing the assets, or administering a trust, whatever the circumstances are. Probably the first place to start is a local attorney. So your son in New York would consult with an attorney in Seattle. And that's a regular part of what elder law attorneys do is, folks will call us up and say, Mom just died. I don't know what I'm supposed to do. And we help with that. We come up with a checklist and help you figure out. Now, the family member typically is the one doing the boots on the ground work, because it's a lot less expensive than having the attorney do it. But if that son in New York needs help finding a crew to clean out the house, or a yard service, or an appraiser, or a realtor, or whatever, elder law attorneys also are a good resource for finding folks who can be delegated to do things like cleaning out and getting a house ready for sale. Okay. I would like to ask, on behalf of everyone here, what's the best way to get started on their planning? I think it's making those decisions. And so I'm gonna type our webpage in here. I think it's also on the handout, but I'm gonna type it. So this can be very anonymous. We have that questionnaire that I talked about on our website. It's under the estate planning tab. And we have one for a single person and one for a couple. And you can just take a look at that and say, okay, what are the choices I'm supposed to make? What's my homework? And you can fill out that questionnaire and get an idea of what it is that you need to get started to get your estate plan in order. A lot of times with folks who are Peggy and my age or older, folks have done their estate plan in the past. It might not be current. Maybe they did it when their kids were little. And so sometimes, it's perfectly appropriate for us to take a look at what you have already and your opinions about, well, I think this is pretty good, but I want to change A, B, and C. And so that's another thing that another way the process works. Typically, in terms of demystifying the process, the way we do that is that the initial appointment, which in 2020 was all virtual. Now that first appointment can either be virtual or in person. The attorney takes about an hour or so and goes through the answers on that questionnaire and finds out what you want in your documents, what questions you have. We do a lot of explaining about how the documents work. And sometimes people will be filling out that questionnaire and just write a big question mark under power of attorney, like, I don't know what to do. And so we help the brainstorming process and help you figure out what the answers to those questions are. Then we prepare the documents in a draft form. We send you the drafts to review. You can make any changes, corrections, ask questions, keep refining the documents till they're ready to go. And sometimes there's another appointment, to answer questions. And then when all of the documents are in their final form, we have you come into the office where we have you sign in front of a notary and witnesses on the documents that need witnesses. So it's not scary. It doesn't have to be scary. Is there a limit on the dollar value of estate that you will handle for planning purposes? No. It's our process. I don't want to get into cost estimates on the webinar, but if you want to call and talk to one of our attorneys, we can give you some estimates. We do everything on a time basis. So we charge you for the time that the attorney or the paralegal takes. And so when we know a little bit more about your situation, we can estimate what that cost might look like. And I have done, I've done powers of attorney for kids the week they turned 18 and own nothing. I've done estate planning for people who have very little, but still want to put their wishes down in writing. And I would say that our firm tends not to help the couples with $10 million or more. That's not our primary focus. If you need extensive tax planning, we generally feel that you're better served by somebody else. But you know, anywhere between 0 and 10 million is we probably can help you. So
Yep.
Okay. So anything else?
Did we miss anybody?
It looks like we have one more question about a question. Where's a good place to get the medical info regarding what types of medical interventions you may or may not want?
Okay, a type of professional that can be very, very helpful, not just on medical decisions, but for medical or long-term care decisions, is somebody called a geriatric care manager or an aging life care professional. So I still tend to call them geriatric care managers, but a few years back, they rebranded themselves as aging life care professionals. And these are typically social workers or nurses in private practice who meet with families to answer the question, what are my care needs? How do I get those met? How do I deal with perhaps conflicts in my family? How do I make end of life decisions? They're really kind of the quarterbacks on all things having to do with the issues of aging. And so I'm going to type another website in here. Well, I'm going to look it up. I'm not quite sure of their website, but Aging Life Care Professionals, they have an organization. So if anybody needs to find that, they can ask me later. But also if a company that we use in Seattle a lot is a company called Aging Wisdom. And so you can find their website and look at what those types of people do. And if that's something that you would like. Some doctors are good with those discussions and some aren't. I think that you would need to know if your family practice or doctor or your internist is somebody you can trust to help you make those kinds of decisions. I think more and more some of the younger docs are getting trained in that, whereas some of the older docs, really didn't have that in their medical training.
We're living a lot longer. Yeah. So there's more of us that need the kind of focus that a geriatric care manager, a life care professional would provide.
Yeah, when you type it in, don't misspell it like I did on the chat. Aging life care professionals. Typing on the fly.
We forgive you, Janet.
Okay.
Well, it doesn't look like we have any more questions at this time, so I think we'll go ahead and wrap up the presentation. But thank you so much, Peggy and Janet, for joining us today. It was a wonderful webinar, and I will say it was just packed to the gills with information. So thank you so much. And thank you to everyone for joining us today. We hope you found the webinar helpful and enjoyable as well. And we will be emailing out an evaluation form, and we'll ask that you fill that out just to let us know if you have any feedback or suggestions for how we can create an even better webinar experience in the future. And we did record the webinar today, so we will be sending the link to that out as well as soon as it's available. So you can watch the webinar again at your convenience or share it with anyone who you feel may be interested as well. And if you would have any questions about University House, or if you'd like to schedule a tour, please give us a call at 206-545-8400. Again, my name is Elliot Hack, the Community Relations Associate here at University House Wallingford, and this concludes today's presentation. On behalf of Ike Elmo, myself, and everyone here at University House, where life goes on and lifelong learning thrives, thank you for joining us today and have a wonderful rest of your day.
Thank you.
Thank you, Ike and Elliot.